Well, thanks, Marjorie, for that awesome introduction. As you can tell, I haven't always been an attorney. I had to work for a living before this, so I like to kind of mix up a little bit of my practical experience and a little bit of legal as we go through the day here. And because I think sometimes if you get stuck in the legal part, you can get yourself bogged down, or if you get stuck in the practical spot, you can get yourself in trouble. So we'll talk a little bit about that. I do have a little story about Cal OSHA before we roll into the presentation. So there's a farmer, and he's sitting there at the farm. He's working, and he owns a farm, and he has a bunch of hired hands. And guy shows up to him, and he goes, "Hey, I'm here. I'm from Cal OSHA. I need to inspect your farm and make sure there's no safety violations." And he goes, "Well, that's fine, but don't go in that field over there." And the Cal OSHA inspector goes, "What do you mean don't go in that field? I'm from Cal OSHA. Do you see this badge? I can go anywhere I want on your workplace. I don't care whether it's the field, the barn, the silo. I can go anywhere I want. With this badge, this gives me the right." And the farmer goes, "Well, I'm just telling you, don't go in that field over there." And he went back to work. Sure enough, Cal OSHA inspector, all of a sudden, he's screaming and yelling and hollering, and the farmer looks up and sees over. He went in that field against the advice, and of course there's a big bull in there chasing him. He's yelling, and so the farmer says, "Show him your badge! Show him your badge!" So, so anyway, that's my Cal OSHA story of the day. The rest will be maybe not serious, but a little better than that. It's always hard without a live audience to see if anybody even reacts to that.
I'm laughing. You have one.
All right. So, as Marjorie had mentioned, we're going to talk a little bit. You can't, in this day and age, you can't not talk about a little COVID-19. I'm not going to go into any in-depth information about COVID-19, but just kind of an overview of where we're at and some of the questions that I've been getting lately, given the Fed OSHA stuff. Then we're going to dive into Cal OSHA investigations and best practices, flow into a little criminal liability, and then talk about crisis management at the end. So when Cal OSHA knocks, hopefully you all that are on this webinar will be prepared for that. So let's just talk a little bit, just to kind of get us up to speed of the COVID-19. I call it the trail of enforcement, and and you guys have probably been dealing with this as safety professionals for longer than you expected. They started enforcing with the IIPP. Then at that point, with the IIPP, the Injury and Illness Prevention Plan, you could basically follow whatever the current guidance was, and then consider yourself in compliance with safety and health when it comes to COVID-19 as relationship underneath your injury and illness prevention program. That's the way Cal OSHA was enforcing that for about the first 8 months of the pandemic. They also, of course, wouldn't apply to anyone on this call, but the ATD standard, aerosol transmittable disease standard, healthcare and stuff like that. And then we got into November, and we got the emergency temporary standard, which was November 30th of 2020, and that's when we got all of these rules, exclusion pay, masks, social distance, all the things now codified into the system to replace the Injury and Illness Prevention Plan. Then roll around to June 2021, and they had the revised version. So that's now today, what we're required to do under COVID-19, and I'm sure everyone is probably aware this is probably old news, so I will go through this relatively fast, but there are some questions that come. Having your CPP in place, which is your COVID-19 prevention plan, it has to be in writing, has to be available. I have had a few fatalities, unfortunately, in the last 6 months that have nothing to do with COVID-19, and one of the first things that Cal OSHA asked for when they got there was they wanted to see the COVID-19 prevention plan, because they got to make sure that's in place. It reminds me of the whenever heat illness plans first became in vogue, where they would always ask for your outdoor heat illness plan, whether they were there as a result of anything to do with heat illness or not. It could be in December. So same thing with CB, so make sure you have that up to date and available. The other thing that gets a lot of people struggling is notices of potential exposure. I won't go into the details, but just a reminder, and this is something to probably work with your HR department on too, is anytime there's a COVID-19 exposure in your workplace, you're going to try to define the area that's the workplace under the standard to narrow it as much as you can. There's a notice that has to go out under what we used to refer to as AB 685, which is a labor code. And then there's also notice requirement under the ETS or emergency temporary standard that Cal OSHA passed. They have different requirements, but you can combine them into one notice except for the notices that go to those that have close contacts. But that's about as much as I'll get on the notices on that. We could do a whole seminar on COVID-19. Another big question we have is vaccination documentation. You do not have to keep a copy of the vaccination card. You can if that's what you choose to do, but you do not have to. And the reason you may not want to do that is because that could arguably become a 30-year exposure record for retention purposes under 3204 and 3203 for record keeping. Title 8, Cal OSHA. So what we're seeing a lot of folks doing, and this is what I would recommend as being a compliant factor, is either having them fill out a declination or a affirmation that says, yes, I've had it and here's the date I got it, or yes, I've had my vaccination, or no, I haven't. And then or just look at the card and then give it back to them and then keep that record. There's a whole slew of stuff on exclusion from work and documentation on that. Just know now that the exclusion, it gets a little bit tricky with vaccination versus non-vaccination. If you have a close contact, if you're vaccinated in the workplace and you have a close contact, unless you exhibit symptoms, you don't have to be excluded for the 14 days or the 10 days. But if you are not vaccinated and you have a close contact, whether you have symptoms or not, you're excluded. And there's all kinds of pay and things that go with that, which I won't get into today. And then one question we always have, do you need a negative test to go back to work if you've been excluded for COVID? Either for a close contact or you actually had COVID-19. The answer to that is no. And the rationale, when you think about it, is you could test positive for COVID-19 for 2 or 3 months after you've had it, even though you're not contagious anymore. So that's what the 14-day waiting period is, a 10-day waiting period is. Training modules. You need to make sure that you're getting your training. I mean, this is Marjorie's forte. This is what EHS does. I know there's a lot of, and I don't mean for this to be a commercial for Marjorie, but it is going to be a little bit. There's a lot of training out there, but the thing that I always worry about with my clients, and I tell them you need to make sure that because there's so much information about the COVID-19 prevention plan, what you're doing, you got to make sure that that's done effectively. And that's the first thing for every single one of my cases that I have that they're looking at. And probably majority of my citations, whether it's COVID or otherwise, there's almost always a lack of training citation. And now we're starting to see them as serious and even serious accident related. So very important on the training aspect. Uh-oh. The slide's not advancing. Let's see what happens. Let me try it this way. There we go. So, what's coming up next in COVID-19? We're almost done with COVID-19 for today. Not for good, but just for today. Round 3 of the ETS is coming. Now, the Cal OSHA Standards Board created a subcommittee with 3 of their board members to meet like every 2 weeks to try to prepare the board and work with the division and stakeholders to come up with whatever round 3 of the emergency temporary standard is going to be. That's been going on. There's been a lot of statistics that have been thrown out. We still don't really know what's going to happen yet, even though we've been doing this since June. We had the Delta virus, or whatever you call it, the Delta variant that came out, and so that kind of upset the apple cart right after they had the June emergency temporary standard where they were taking masks off and doing all the things, and now we see that movement. So they're thinking about coming up with a 3-tier type system within an emergency temporary standard. So basically, overturning the whole system. There is talk about that. I don't know if this is going to happen, but basically, you have if it's a white zone or in your area, you follow these rules. If it's a blue zone, I'm just making colors up. You do this, and if it's a red zone, you do that. And they're thinking about that. That's been bantered about quite a bit. So we'll see what happens with that. And then the other thing is the being able to be dynamic and change with California Department of Public Health guidance. It's constantly changing. So there is a push to go back to, hey, we have an IIPP, we have an injury and illness prevention program in California, we have guidance from the health professionals. Why can't we do what's reasonable under that guidance for our workplace and be compliant with the IIPP and enforce it under the IIPP? So there's that argument going on too in the background. Then, to sprinkle a little craziness on it to add to our woes, is we had the federal mandate that came out from President Biden's office regarding the federal emergency temporary standard and vaccination mandates. Okay, so we're in California. I have this question all the time, and it's probably worth saying here is California would have to adopt and go through a rulemaking process to adopt that. There's a system called the Horcher adoption. So there's a way to do that in an expedited fashion, but it doesn't happen in a day. And so we'll get notice to be at a standards board of whatever they're going to do with that. But there has been a lot of discussion, a lot of questions we've had across the country for what that's going to do here in California. So right now, no matter what happens at the feds, it's not going to be effective the same day because they got to adopt in California. So stay tuned on that. There is also a discussion point about a permanent pandemic regulation. They're working on that. I'm hoping that it'll be something along the IIPP realm, but we're yet to see. So we'll see what happens with that. And then last but not least, there is a Cal OSHA COVID advisory committee. Now, it's open to the public, so anyone can watch, but the discussion on the agenda is for COVID advisory committee members, which is about 40 of us. I happen to be a member. And so we're going to be talking about what we want the ETS to look like and when it's comes up in December for its last round of emergency adoption capabilities, and probably a little bit about the permanent. So stay tuned on those points. All right. Tired of COVID-19 now. That's it. I'm done with COVID-19 for this discussion. If you want more information, you can hit up Marjorie or myself or both of us. And if you hit Marjorie, I know it'll be right. If you get me, it'll be 50-50 chance. I might be right, I might be wrong. So you guys can figure that one out. Okay. So I know that in this particular call, there's probably not a lot of HR. There may be some HR. There's probably not any in-house counsel. But whenever you're dealing with Cal OSHA and your roles, kind of need to figure out where you're at and what your role is. Are you an outside consultant working with the water districts? Is your safety department and HR combined? So those things are going to have some bearing as we go through here. So let's start with managing Cal OSHA investigations. I don't know if I can do a pop quiz. Does anybody recognize the Cal OSHA guy on the right? Do you recognize him, Marjorie? That's Brandon Hart. I just realized that it's a picture of somebody I know that has been in this generic thing I pulled off the website.
Yeah, I didn't recognize him.
Anyway. So First thing we're going to talk about is opening conferences, and we'll get into some details on that. Then, of course, the walk around or the investigation that pursues once they've done the opening conference. We're going to talk about document requests, employee interviews, and then a closing conference. And then after that, we'll get into some dealing with the appeals and crisis management. So I get this all the time. Why is Cal OSHA inspecting my work? Why am I even under investigation? Why do they even care about my particular water district, or why are they here? Well, it could be any of these, but I'll go through them. And there's a couple that are at the end here that aren't exactly by mandate, but it happens. So employee complaint. First of all, if an employee complains to Cal OSHA, they're mandated to do an inspection. Now, they have figured out a way around that so they don't put boots on the street. They don't show up at your plant every time, but you may get a letter and a complaint letter. So if you get one of those, be careful about how you respond to that. But that's one way an inspection starts. The other is obvious. You've had a serious injury. You reported. We'll talk about reporting the serious injuries. The other is programmed inspections. Now, prior to COVID, we saw that a lot. We'll probably see that again. And that's where they take a percentage of the workplaces in California from different segments, and it randomly spits it out of the computer, and they head out and do those inspections to meet their numbers. Sometimes it's an emphasis program. I don't believe you guys have ever been on the emphasis program. It's usually like roofers or meat packing plants or some other industry, but sometimes it's an emphasis program, and they'll do the sorting through that. Referral, you probably don't see that often on referrals, but referral means one agency reports you to the other agency. So the labor agency calls Cal OSHA, says, hey, I'm out here for a labor issue. I think there's some safety issues because there's a guy hanging upside down from the rafters, so you should get out here, and that's a referral. Now, this is one that gets people. Is fire department. So you call 911. The fire department rolls out with the paramedics. It turns out that whatever injury you called them for wasn't even serious. They went to the ER or treated and released, or they rolled out and they triaged, and it turns out that, for lack of a better term, false alarm. Well, anytime a fire department or ambulance rolls to a job site or a workplace, regardless of the level of injury or whether the injury is work related, if they roll there, they have to report that or they get a $5,000 fine. So what happens is sometimes it's not as serious, so it's not reportable. Cal OSHA still rolls out because they've got a fire department call and nothing from the district that says, hey, the fire department was here, it's not serious, or they didn't get a serious injury report. And so they may show up as a result of that. And then if they show up and they get consent to inspect, which we'll talk about consent in a minute, you're going to get an inspection. Even though the law doesn't require them to inspect every time they get that report, they will, because it looks like something's not been reported by the employer or by the district. Then the other, and you guys have probably seen some things in the news in the last few months at some water treatment plants, but they hear about an incident in the news. Sometimes they'll roll whenever there's something major in the news. I've had that happen probably 4 times this year on fatalities that I've been dealing with in different industries across the board. And so that happens. You still, by the way, if that happens, if you have a catastrophic injury or a death and Cal OSHA shows up and you say, oh, well, I guess I don't have to report, still make the report, because that's a $5,000. I've had that happen where you don't have the official report of it because they showed up. Make sure you either clarify directly with the inspector that, look, do I need to call this in? No, because that's the inspector. Make sure you have a note of that, or call it in even though they've already been there. Avoid a $5,000 penalty.
Sorry about that. I have a question from Lori Rigby.
Sure.
It says, what about them providing the compliant at the opening conference? Is that a requirement for them at the initial contact?
Providing the complaint?
Complaint, yeah. Sorry.
Okay.
It says compliant, but she meant compliant.
That's right. No, they do. They do have to give you the basis so that you can have informed consent. I'm going to get into that in a little bit more detail, but they don't. And in fact, you probably don't want them to, and I'll tell you why in a second. If it's a complaint, that's confidential. You don't get to know who it was or what exactly it was whenever they're there because they don't want anything that can identify the complainant. Now you say, why the hell would I not want to know that? Well, because of retaliation claims, which is outside of Cal OSHA, but if there's any hint, if you don't know who complained, there's no way you can retaliate against them and create another lawsuit out of it. So that's why I don't worry so much about not knowing who the complainant is. And I will give you this, probably 9 times out of 10, the client knows or has figured out who the complainant is or something just by the nature of situations in the workplace. But you really don't want to know who the complainant is. But they do have to tell you they're there based on a complaint so you can give informed consent. That answer question? I don't know why I'm having trouble with
You
the
said
40
yes.
here. Okay. Okay, I want to go through real quick injury reporting because we get a lot of questions. There's a slight change to injury reporting. One was obvious, the other one is not so obvious. So in Title 8, Section 342A requires you to report to the local district office of Cal OSHA serious injuries. And serious injury is defined as in hospitalization for other than observation. Now, what I want to point out here is that the old law a couple years ago, this changed. The old law was 24 hours or more for other than observation. Now it says just in hospitalization for other than observation. So if they're admitted, now it doesn't mean the emergency room, but admitted, that means it's reportable. Amputation's obvious. And one thing they added was loss of eye. I thought that would count as a loss of a body part, like the old regulation said, but loss of eye is reportable, which makes sense. Fatalities, of course. And I one time made a mistake when I was talking about this and said you only report serious fatalities. And then I thought for a minute, I go, I guess all fatalities are serious. And then I rethought it and realized I have an ex-mother-in-law, so maybe not all would be serious. That was a bad joke. I'm sorry. So how long do I have to report this? Well, it says 8 hours, but it says immediately, but within 8 hours. So technically you have 8 hours to report it. Personally, I like to report them relatively quick, and I'll tell you why. The strategy. One is it says what information you have at the time of the call. If you call 4 minutes after the accident, they can't expect you to have much, but you've met your obligation under 342A to get it reported, write down who you talked to, and follow up once you've had a breather to figure out what's going on and give them additional information, but you've met your obligation to report. You know, if you know the name of the injured, about what time it happened, etc. Just those few things, and then you can always follow up. Another thing, a little trick of the trade with this is, remember I talked about the fire department? If I have a fire department call and it's not serious, I will call and say, hey, we had the ambulance roll here. It turns out it was a hangnail. It's not serious, so I didn't want you to end up having it put on your books and wasting your time. Sometimes they will ask you for, if they went to the emergency room, they'll ask you for the name and birth date of the injured employee so they can call the hospital and verify you're not lying to them. But I do this for a lot of clients now, and it's cut down. Well, I probably lost a lot of business out of it because it cut down the inspections by about 70%. So, but it's worth it at the end of the day to avoid that inspection. Okay. The inspection begins. By the way, feel free if you guys have questions as we're going here. The inspection begins. So what's the first thing you do when an inspection against Cal OSHA shows up? You got to alert whoever the official, whoever is the appointed person or anointed person, however you want to put it, to deal with Cal OSHA and investigations at the site. You need to let them know and let management know. Then the second thing you do is request the inspector's credentials if they don't show them to you already. And you may think, well, that kind of, why is that so important? Well, because there are some folks that have been out, and this has happened several times, that pose as Cal OSHA inspectors and go out and try to get pretend like they're a Cal OSHA inspector. And ironically, of course, it probably may not happen at a district, but it could, where they ask for cash at the end or to pay for the fines that they were just levied, and they were fraud, and they actually had felony charges brought against them and were caught. And this has happened 2 or 3 times in the last few years. So request their credentials. They shouldn't frustrate the inspector. They should be used to it, and they would know that that's part of it. Usually they'll just go ahead and show it to you right off the bat. And then this kind of goes to Lori's question earlier, is determine the purpose of the inspection. And what do we mean by that? Well, you have to give consent to the inspection, which we're going to talk about in a minute. But you need, in order to give consent, you need to be able to know why they're actually there. So, is it there for a complaint? Okay, they're going to get, if they're going to be able to. That's a right they have. I'll give you an example of one where I may not give consent based on the purpose of the inspection. And remember earlier when I was describing the fire department call, and we say, okay, the fire department rolled, they call in and say, hey, I went to one of the water districts for an employee emergency. Turns out it's not serious. You call them and say, hey, this wasn't serious, doesn't meet the criteria, so ignore the fire department report. Or I've also had it where they went to the hospital and we don't know if they're going to be admitted, and then call the next day to verify, hey, it turns out they were treated and released and were never admitted in the hospital, and it comes off the book. So those two things. If they still show up and they are basing their inspection on a serious injury, then you can say, well, time out, the injury wasn't serious, so that doesn't give you, so I don't want to consent to the inspection based on a false premise, because it is false if their reason is that it's a serious injury that's been reported because the injury wasn't serious. You've already verified that and done that. I've had that happen twice. And both times, once it was realized, it took a little bit because the inspector is thrown off guard because they're not used to that, and they expect that. Remember the guy with the bull and the badge? That's how they're looking at this. Here's the badge, and you're saying, wait a minute, there's a bull in the field, and they're saying, well, I got a badge, I can do what I want. And in that case, they can't do what they want, and so those inspections didn't go forward, and for good reason. So that's why it's very important to determine the purpose. The other thing, it will help you with establishing like the scope. If they're there for the accident, try to limit that scope of what the inspection is to the accident, because you don't want them doing a wall to wall. Limit if they are there because of a complaint, they may not tell you what the complaint is, but they can give you a general idea of what the area that they need to look at or what have you. So very important to make that determination. And of course, it is important to insist on an opening conference. What's an opening conference? That's where Cal OSHA kind of goes through and they talk about your rights, their rights. They mostly just educate you on the process. It does 2 things. One is it allows you to get a feel for the personality of the inspector before you start walking the site, which those non-scientific, non-legal things make a difference, because you want to try to relate so that you can kind of build that cooperative relationship with Cal OSHA as the investigation as it pursues. Number 2 is it may give you some hints of what the complaint was or where they seem to be their focus points as well. So always make sure you have that opening conference and get a feel for what's happening. Um, the
Kevin?
other thing, especially if it's an injury related or a fatality, you need to treat the inspections kind of like litigation, because that's what it is. This is the first round of the state Cal OSHA versus the employer moving forward in what could become an appeal. Citations could become an appeal in litigation. So you need to kind of think of it that way. Especially, and the reason I say especially in the context of a serious injury or a fatality, and we'll talk about that, but there's larger ramifications than just citations that you can get in those contexts. If it's a straightforward random inspection, programmed inspection like I talked about, maybe not as important. They may get citations, maybe appealable, maybe not the same level of stakes. So you can loosen up a little bit. But if it's a complaint inspection, antennas need to go up, because there may be a lawsuit coming on the other end of retaliation or some sort of claim that has nothing to do with safety, but pinned on this safety issue.
Kevin?
So just,
Question?
yes.
I have Rosemary's, her question is, so can you limit the actual inspection to only a certain portion of a facility or plant?
Yes and no. You can agree on the scope and you can withdraw consent every time. That's a tricky business in withdrawing consent, but it's not so tricky limiting the scope and do it in such a way that they don't even kind of realize it. Say, hey, do you have a sense of where you want to look, or kind of guide them into the limited scope. Let's say they want to look at the I don't know, the crane that's in over one of your pumps. Okay, well then you know that building and that's where they want to go. Maybe they want to look at, there's something happened over around the skimmer somewhere. Then you want to, okay, try to limit and keep that guide. The other thing is that you can also help them with the route. They may not know where they're going, and so you can kind of choose the route of how you want to get them there so they see the least amount of things on their way. I don't know if that helped answer, Rosemary.
I think she responded, it seems like yeah, she said thank you. I believe,
Okay.
Rudy, were you gonna say something?
Yeah, I was gonna start typing it, but I don't know. I don't even know how to ask it, so I'm gonna do it verbally.
Okay.
Yeah, sure.
So recently we had an inspection. We suspected, just because of the timing of it, it was due to a complaint. But I think at the time, me and the compliance officer didn't feel we had the right to ask that. And now we know we do, to get that intent, purpose of their inspection. So Lori can speak too, but we didn't ask if it was due to complaint. We assumed it was, but the inspector was really vague as to why she was there. I honestly don't even know why she was there. She seemed to imply that it was an initial inspection to be followed by a secondary inspection, but it wasn't really clear. And is there a list of reasons? I think you did show them.
Yeah.
I guess maybe we need to know those reasons why they need to be there. And the fact is
Yes.
that she didn't really give us a good reason. And what is at our disposal now as we still continue to deal with this inspection and the following report,
Okay.
because they
Well,
didn't make it clear why they were there.
yeah. Well, the once you consent to the inspection, then you've consented. Now you can withdraw consent, but to your first question, Rudy, the list, the list behind that is on one of these slides. You get a copy of these slides, but again, the biggies is they're there for a complaint. They have to tell you because they have to have jurisdiction, and they have jurisdiction. They has to or in a random inspection. One thing I didn't put on the list is if they see something open and obvious, they're driving down the road and look over and they see somebody on top of a tower not tied off or whatever. But that's another reason. Referral programmed, and the fact that she wouldn't give you the purpose is a red flag. Now, what was at your disposal at that point? time out. We're not going to consent yet. I do have a right to know. I want to cooperate, but we have a right to know the purpose of the inspection for your jurisdiction. That may be too fancy a word, so I know why you're here. Because if I'm going to consent, that's what they're going to say. Well, I can just go get a warrant. I go, but you have to have a rationale for that. So just we need to know what the purpose of this is. They shouldn't give a lot of the old timers won't give pushback. They know, they've been down the road. There's a lot of new inspectors out there that just are nervous and they don't really quite, and maybe they went to one of the internal courses. They don't go to Marjorie's training, so they don't get that well trained on things. So they may not realize that's a law. I have to have that discussion all the time. Now, and I don't want to sound self-serving, but if you're in a situation like that, even if you're not a client, maybe someday you'll be, pick up the phone and call me while they're sitting there. I'll answer, and I may know the inspector. I'll be able to talk them off the wall or whatever, and then we can decide what to do next. But that's always an option. My number's at the end, so you can do that, and we can. There's a lot of. Sorry, go ahead, Rudy.
Oh, I think that Lori may have a better understanding. It seemed like the inspector was very new, but we have these so seldomly. I didn't know exactly how to deal with it. But now it's good we have this class. So maybe Lori can speak to what her impression of that inspector was, so that we all understand what we could have done differently, I guess.
Lori, do you want to unmute yourself?
I'll unmute. Thanks, Rudy, for calling me out. Man, and I actually had a follow-up to what Rudy said anyway, but I don't necessarily feel she concealed it, but she did not volunteer the reason she was there. And she was a little vague because I tried to kind of ask her a little bit, I'm in an inspection. My approach is always let them lead. It's not my inspection. I am only there to answer questions. So I'm not likely to push real hard. I really try not to talk myself into a wall. But she was vague. She did not provide me any documentation. I did somewhat ask for it, say, hey, can you show me the reason you're here? And another thing that I tend to do in an inspection, since it's not my inspection, I don't like to basically give a tour, right? Like, okay, well, we're going to show you the process. I tend to like the inspector to lead. So when someone comes in and just says, okay, show me around, I get very uneasy with that because it's not my inspection. I don't know what she wants to look at. I really want the inspector to lead. So how do we overcome an inspector who just basically says, well, give me a tour? And you kind of address that a little bit, but maybe you can elaborate for those people who just want you to walk them through the entire process when, it may or may not be necessary.
Right. And that's a good point, Lori. Thanks for bringing that up. That's what I meant by, although you like you say, you want it's their inspection, but if they're giving you a little control, then you can control the direction of where it's going without really letting them know. So that's what I meant. Like if they say, I want to see everything, well, they were vague. You did decide what everything is, right? And maybe it's only this one area or what have you, or you walk around the perimeter of the place where they can't see anything. So you can take control. Obviously, you don't want to be too obvious. That's a little bit, but that's and you can try to pin them into, well, what exactly are you looking for? Now, there is a caveat to this. There's always a caveat to everything. Cal OSHA has a right, once they have jurisdiction and the purpose of being there, to do a wall-to-wall. Now, just a little bit of history. Cal OSHA never really did wall-to-walls. They always did, okay, if I'm there for a complaint and it's a saw guard in the back room, that's what I'm going to look at. And that's what I'm going to check out, and I'm going to get out, and I'm going to do more inspections a year. Or I'm there for the injury, I'm going to stay in that little circle. Or if I'm there for a heat illness sweep, I'm going to do the heat illness and check the IPP and get the heck out. Then the Brown administration kind of changed the direction of the policy in that, hey, when you're there, it takes as much effort to do a wall to wall as it does to single because of all the paperwork and everything involved in inspection. So there was a trend there for a long time that they were doing wall to walls regardless. And so we didn't have a lot of control over that, other than maybe if we didn't tell them there was a wall behind that wall, we could hide that fact or not worry about that. But that, and now I see the trend, kind of to your point, Lori, is that they are limiting it more there because they're trying to get more inspections done and trying to get a little bit more narrow now. And so I have seen that policy shift a little bit, but it's been a little bit slow in shifting, and so part of it depends on the personality of the inspector you got. I'd like to ask who the inspector is, but I don't know if that's probably too much detail for this forum. But I will, offline after this, if you want to give me a call, probably not today because I'm booked today, but tomorrow or Friday, I can kind of talk to you a little bit more in detail about it and give you some ideas.
I added his email in the chat menu. Also, Edward has a question. Can anyone of staff give authorization to the inspector to begin the inspection, or does it have to be someone in supervisory position or higher? That's clearly an organizational policy, but
technically, no, it can't be staff. And the way the law is basically, would the inspector have a reasonable understanding that that person had the right and authority to give consent for that employer? If it's a guy or a gal with a wrench tightening bolts on a pump housing, and they say, "Hey, do you mind if I come in?" "Oh, sure, go ahead." That's not going to fly. But if they come out and they say, "Hey, I'm the safety liaison, and go ahead and come on in," if it turns out they're not management, then there's going to be an argument whether the Cal OSHA person should have perceived, and then there's this issue of that person holding them out without permission, so that's going to be a quagmire. But the answer is it should be management, and generally speaking, I don't ever have that issue. And in your context with the water facilities, not as much, because they're going to go into the office. It's not like a construction site where the general contractor consents for, and then you got 4 subcontractors say, "Hey, wait a minute, I don't know, I got consent from the general, so I can do what I want." So, but chances are they will go into the office, and then whoever is there needs to understand to have them slow down and wait until the right person gets there. Any more questions for? Great questions, by the way.
We're good, Kevin. Thank you.
All right. Okay, and we kind of been talking about this already. So now they've shown up, and so you got to kind of balance your approach, right? There's a balancing act between cooperating with them and preserving your rights as an employer, and they don't always align. And so it's kind of like what Lori and Rudy's example was before with the consent was it based on a complaint? Seemed like it was. How much do you want to push back? How much do you want to preserve your rights? And so that balancing act is always going to be there as we go. So we kind of got ahead of ourselves in the last, but the consent we've talked about, and they have to have a warrant. Now, let me talk about warrants for a second. I never recommend forcing them to get a warrant, but I do have some warrant stories. One is where they went and got a warrant before I was involved with the client. Of course, I got involved with the client after they got the warrant because everybody was PO'd and it was just a nasty event. But there can be a thing where you're trying to consent. Remember earlier I was talking about consent and scope and that, or we'll get into this a little bit with interviews too. And so I have said and pushed back and said, look, we're consenting, here's the scope, are we all good with that? And then they want to do something that's against our rights, are the employer's rights, and they threaten a warrant. I said, hey, we've consented to inspection, but here's the limits, and you aren't supposed to do that. And so sometimes we have that pushed back, but I don't ever recommend getting a warrant. And I do have an open case where we consented. We gave them like 1,200 documents, and then somehow, and this inspector, ironically, has left the division, but they've allegedly falsified the fact that they already got 1,200 documents and based a warrant on the fact that we hadn't given them documents. So that was the only other warrant story I have, which that one's yet to be determined in the fight. This is a little bit of a strong word, permit the inspection as long as you agree to our inspection protocols. That doesn't mean that they're forcing them to agree to everything, but I will tell you what it does mean. And I have had this is, look, in this area that you want to go, we require a respirator or a PAP or whatever it is, or we require Nomex suits, or we require steel-toed boots with metatarsal, whatever it is. And they say, well, I don't have those. Well, we can't go in there because you have to have that proper PPE or the proper safety. And it does two things. One is it shows them you enforce your safety requirements. And number two, that sometimes by doing that, you slow them down and make them think because they need to be following safety protocols too. I do have one, and let's say we got an hour here. I have one little funny story about this is we're talking about balancing cooperation versus preservation of rights, and on this issue of inspection protocols. I was on an inspection, and the inspector wanted to take photos of inside a electrical cabinet. And I said, oh, sure, happy to. But you have to wear the 40 cal suits or whatever it was that they had to don because there's very high voltage in this cabinet. And I saw he had an iPhone. And so I'm all, this is perfect. I had to cooperate, but also still manage our rights. So part of donning the PPE for this electrical box is you have to wear these big leather gloves. Well, I know we can't take pictures with those big leather gloves. And so I hand him, we suit him up, give him the gloves, and then I hand him the phone. And then he realizes, wait a minute, I can't take a picture. I go, well, we can't go in there. It'd be unsafe without these gloves and everything on. So we didn't get his pictures. And inside that cabinet was a mess. So I was glad I didn't. And we avoided citations and cooperated all at the same time because we provided in the PPE. So that's where you can do that balance of cooperation and still be the good guy or gal in the inspection. Okay, we kind of talked about this a little bit, but it is very important at the opening conference to designate who the main point is. And like I hate to pick on Lori and Rudy, but like you guys had your inspection, you established, okay, Lori is the point of contact for everything, or Rudy was the point of contact for everything. But establish who that is for everything so you can control the flow in and out in information that comes from that. You guys may not have any trade secrets, but in some cases that's an issue. Let's say you've created this really unique safety program that you're the only district that has it, and you don't want to share it with the other districts because this is really cool for you. Make it confidential and trade secret so then it doesn't become public knowledge once you provided it to Cal OSHA in their document in response to document request. So there may be some times when you do that. I think I just advanced the slide without knowing how to do that. Inspection. So once now you've had your opening and now you're out, you're ready for the inspection. Make sure you're with them at all times. Very, very important. Accompany them at all times. Now, there are times where they may want to talk to an employee, which we'll get into in a little bit, by themselves, but there's a protocol we can talk about with that and how to handle that. But you don't ever want them wandering around a place by themselves. The other is they may be going through their inspection and saying, hey, I need the IIPP, I need the heat illness plan, I need your lockout tagout plan, and you're taking notes. Well, require them to put a document request in writing. That way you have it, know exactly what they are. They're on their form. Most of the time they'll do that. That's not a big ask, but that way you can track. And if this thing goes forward, you have a well-documented trail of what they asked for versus what you gave them. There's a couple of things, though, that they ask for that when they're at the site that you need to be able to provide almost immediately. Number one, it actually does say immediately, and that's your outdoor heat illness plan for folks and your COVID prevention plan. Those are immediate upon request out at the workplace. The other one that gets people are the 300 logs, the recording of work injuries. The 300 logs, there's this little esoteric regulation that says that they have to be provided within 4 hours of the request, and that counts as an oral request. And so I've had this happen where they ask for it out there and then they put it on the document request. The client doesn't realize that they need to give that in 4 hours, and then they get a penalty even though they gave it to them with all the other documents for failing to give it within 4 hours. Kind of a chicken poop way to do it, but that happens. So know that 300 logs are required to be given whether or not they're in the written request within 4 hours of the request. So whenever they are taking samples like air samples, say in your plant somewhere or anything of that nature, make sure you have your own IH taking their own samples at the same time. And I have done this many times, and it's interesting to find out that sometimes their sampling is not as accurate as you would think. And also they make mistakes because you have your professional there, your IH doing air sampling. I had one where they dropped the vial. It was, lost a vial. There's all kinds of things that happen. So do that side-by-side sampling. The same thing for photographs too. We don't get the photographs until 6 months later after the inspection begins and they've issued citations. We've done a request for the file. So if you take the same photo they take every time, and it's a good opportunity to say, hey, I'm going to take, and they don't care. A lot of times we tell you, hey, if you want to take the same picture, that's good because they recognize that protocol that happens, is you can ask them, hey, what are you taking a picture of so I can make sure I get the same picture instead of just standing beside them. So it gives you a chance to get information from them without it seem like you're fishing. And that can give you hints of things that are coming up. Now, employee interviews, when I say must be scheduled, it isn't necessarily a must, but I try to, we get the opening, we do the inspection, and then let me know who you want to talk to. They may want to talk to someone random in your site, but I try to avoid that as much as I can so I can prep the employees before they speak with them. Management, absolutely. If they're supervisor or above, they can't talk to them random. That needs to be scheduled. If you have counsel, if it's an accident or fatality, make sure your counsel or general counsel's there for those interviews, because management, anything they say can be an admission. So, I think I went backwards, didn't I? Sorry, this is my first PowerPoint. No, I'm kidding. We talked about some of this already, but considering the accident scene, figure out the route. We talked about this. Was one thing we didn't talk about earlier when we were talking with Rudy and Lori about their situation. There's a plain sight doctrine too. So anything they see that's in plain sight during their inspection in California, they have to cite you for. So keep that in mind. The days of them used to well, just fix that and I'm not going to write it down. There may be some old timers that will still do that, but for the most part, if they see it, they're writing it up. So make sure whatever route you're taking is the cleanest with the least amount of potential visual hazards that you can find. Now, the other thing is, and Lori, I hate picking on you, but you said it best, is you're just there to answer questions and it's not your investigation. Avoid making damaging admissions. If they say, hey, look, that guardrail is missing, don't say, oh yeah, I noticed that the other day. I told Jill or Joe to go put that up. I can't believe they didn't put that up. No. Your answer is, thanks for letting me know. I'll check into that. Then you haven't admitted it's even wrong. You haven't admitted that it needs to even be there. But in the back of your mind is saying, oh, whatever word expletive you want to do, I need to get Joe and Jill to fix that like I said 3 days ago. But if you say that, then you just admitted to a potential willful violation, right? And you were just talking because the inspector, she was really super nice and you were cooperating and you're in the flow of conversation. So you want to avoid admissions. Like I said, keep the employee conservations to a minimal. Here's one of your key roadblocks, if you will. There is in the labor code where it says that Cal OSHA during their inspections cannot unreasonably interrupt your normal operations. And so if you have someone, an employee that's working and operating this piece of machinery, they can't go tap them on the shoulder and say, come on, because that's unreasonably disrupting. So there are some ways around it. So keep that in the back of your mind. And the other thing you can do is say, hey, we can set these all up. We can get them done in a day. Make sure that they're available and at work and whatever the issue is. And you can kind of make it a benefit to them when they're wanting to do employee interviews. The other one, this is a big one. Need not demonstrate any machine process. Never, ever, 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 ever demonstrate or recreate the accident scene for the inspector. We do not have to do that as employers. They ask to do that on. Can you show me what they were doing whenever the accident happened? No. Why? Okay, first of all, why would you ask that, Mr. or Mrs. Inspector? Because there is an accident doing what you're saying that you're asking me to demonstrate them to. So that's one reason. The other reason is there's no way to recreate. You don't have to do that. They get to see what they see. They get to take pictures of what they get. They get to do their interviews, but they don't need recreations. And I've had that happen, like put the scaffold back up the way it was the day of the accident. No, here it is. This is where it is. This is how it is. It's preserved as is. But we're not demonstrating anything or recreating anything. You'd be surprised at how many times that folks do that, trying to cooperate. A couple things on document production and document requests. One is, like I said earlier, have a single source of contact for documents, even though that person may not be the one that has control over all those documents. They may come from different departments or whatever's being asked for, but have one single point of contact and then you manage it inside. Also make determinations if the documents are privileged. Did you have a conversation about the inspection with your general counsel? Did you have one with outside counsel, with me? Or is there a document about that? That wouldn't be necessarily produced. Or if it's an accident, the accident investigation, if it was at the direction of counsel or it was by a third-party investigator that was at the direction of counsel, may be privileged, and the root cause analysis on that you may not have to provide because it's privileged. Determine what they're asking for. Is it reasonable trade secrets? I don't think we have to worry much about that. Another key is only produce what they ask for. And you may say, well, I got this document that might get me out of jail. Well, you can always provide that document in defense, but there may be things that they get out of that they didn't ask for that leads you to other citation. So if they ask for the lotto program, don't produce a bunch of training records and audits. They need to ask for that. If they ask for your IIPP, give them that. Don't give them your 12,000 page safety plan that has a bunch of things to go through and find other things wrong. Just give them the injury and illness prevention program. See that happen quite a bit. So now let's talk about managers. This is your supervisor. Supervisor interviews. And I alluded to this earlier. Statements by the supervisors, they're basically an admission on behalf of the district. It could be the chairman of the board saying it, or it could be first line supervisor saying it. It carries the same weight for admissions as far as Cal OSHA is concerned in these interviews. So very important. If it's a serious injury or a fatality, unfortunately, you need to make sure you've got representation there. Get with your general counsel and make sure the supervisors know not to talk to Cal OSHA without some representative being there. And different from employees, managers can insist that the interview is with an attorney present for the company, and even the company, even like for one of the safety professionals, you've been to the seminar, you know, and the supervisor walks up and he wants to talk to them and say, hey, we're going to schedule this supervisor later. We're not going to do his interview now, and they are used to that. Cal OSHA is used to that, but that's a very important thing to remember because of the admission. You need to make sure they're prepped for it. The other thing, a recording. People want to record these interviews, or Cal OSHA inspector wants to record the interview. I do not believe that's a good idea, and I'll tell you. You say, well, why not? Doesn't that preserve what was said, and then it's accurate? Yeah, but the questions they ask are not always good, valid questions. There's no judge there. There's no court reporter. There's no one to object. There's nothing to object to the form of the question. And so when that recording is done, it's very hard to unring that bell. Other thing, in the state of California, you're required to consent to a recording. That's why when you call these numbers, they have that little message, because by staying on the phone, you consent, right? So same thing with this. You lose a lot of opportunity to object to what was stated if they put them in their notes versus a recording. So I don't recommend a recording. And then as far as your interview is concerned, if you're a supervisor, you kind of need to prepare for it like you'd prepare like for deposition or other legal proceeding. Now, employee interviews, it swaps around a little bit. Here's the thing that I always remind folks. Who holds the rights? Does Cal OSHA have the right to interview the employees? Does the management have the right to control the interviews? Well, the answer is neither one of those. The employee holds all the rights. The employee has the right to talk to them, has the right not to talk to them, has the right to have a supervisor there, has the right not to. Has the right to have a union representative there, has the right not to. Has the right to talk to them or not at all. And so they actually hold all the rights, and it's important for them to understand that and make decisions. Because a lot of employees, they may want one of you in the room with them when they talk, because it makes them feel more comfortable, because there's this government agency here questioning them. So they need to make sure the employees understand that. And they have a right to prepare for an interview. And you have a right to prepare them if they so want to be represented or have you with them in the room. And you can still cooperate with the investigator's intent to interview, but make sure the employees understand their right. And then I also highly stress encouraging these two things. One is encourage them to tell the truth. No matter what they say, they're not going to get in trouble. The truth is all we care about. And if it's bad, it's bad. If it's good, it's good. It's not the time for opinions, but it's time for the truth and factual truth. And then number two is, although they have a right not to talk to them, we hope they do, because we're trying to cooperate with Cal OSHA and the authorities, so that cooperation is important. And so although they have a right not to talk to them, we hope they talk to them. And that avoids any retaliation, any interference claims that they may have, Cal OSHA may have, in regards to those employee interviews if you're trying to control them. The only exception to this right to decline interview is if they're subpoenaed. So, Okay. Well, we just finished the inspection finally. We're 10:16 and we're done with the inspection. Now we're having our closing conference. One is ask for a closing conference. Now, sometimes if I'm representing a client, I won't ask for a full-blown conference because I've heard all the rights and remedies and the right to appeal and all that. But I do use the opportunity to get a sense of where they're coming from with their citations. But I don't get into any disagreement or any argument with them at that point. I just listen, absorb it, and I might talk a little bit about abatement with them if it's something that they want abated, and if necessary. But generally what I'll do, rather than getting full-blown into abatement, or what I recommend, absorb those and then maybe call them back and say, hey, here's what we're doing for abatement, or send them in what you're doing for abatement, and then they'll call you and say, we want something different, and you guys can negotiate that. And then correct any misunderstandings. Sometimes there's misunderstandings that occur. It's not the time, though. What I mean by that is try to get everybody on a calm page if there had been issues, leading up to this. The other thing, it's not the time, though, to try to argue that they said that the guardrail was down and you say it was up. That's not a misunderstanding. That's an appealable issue. So try to end on a good note is the best way to put that. Now they've issued citations. They've issued a notice of intent to issue a citation. So I don't know if any of you, probably no one on this phone has ever gotten a citation before. So in case you haven't, let me explain what there was something that passed a few years ago that requires Cal OSHA to give you a notice of intent to issue a serious citation. That was adopted during the Schwarzenegger era, and so the administration and the use of this was a little different then. It was supposed to be the concept that, hey, before they issue citations, let's just have one last talk, because maybe they should be a general instead of a serious. Because although they did something wrong, although the employer did something wrong, Cal OSHA should consider that they did everything reasonable and responsible, and just happened to mess up on this one day with this one citation or two citations, and that was what this was supposed to be. Well, fast forward now, administration has changed and things have changed, and now they'll use this response as an admission. Because keep in mind, the whole idea of this is, hey, I did something wrong, but it should be a general instead of a serious. That's the only issue that the notice of intent is supposed to be addressing. It's not Independent Employee Act offense. It's not lack of jurisdiction. It's not none of those other. It's not they cited the wrong safety violation. It's not that, hey, you got it wrong, we didn't violate anything. It's not that, because by sending that back in, you have admitted you've done something wrong. You're just saying it wasn't as bad as they think it was. So before you respond to one of these, and a lot of folks will want to do that because it seems like an opportunity to get out of a citation, think a couple times before you do that. The other thing I've seen them do, Cal OSHA do, is take what information was done in response to that and change it into a willful violation based on that information. So you have to be careful if you do decide to respond. Then citations and classification. Most of you are familiar with this. General, serious, accident-related, willful, repeat. Couple things to keep in mind is that these citations can be used if it's an injury case in what's called a serious and willful claim under workers' comp, where they claim you violated a regulation and it's caused the injury, so they get a big 50% kicker on their workers' comp claim if they can prove that. So half the battle is proving there's a violation. So if you just pay the violations and move on, you've now admitted to the wrong. That's half their case. Same thing with criminal prosecutions in relationship to fatalities. So you have to be mindful of the effects of the citations. The one thing that comes up repeat. We're seeing this more and more because they changed the law a couple years ago on repeat. It's now a 5-year tail, and it also used to run from the date of the issuance of the old one. And so if it passed the 3-year mark under the old law, then you were out of the woods for repeat. Now the clock doesn't start until a final order or of the citation that they're claiming you repeated again, and that runs for 5 years. So that's a bigger issue nowadays. Okay, yes.
Just a quick question here. It says, should we prepare lockout tagout audit monthly or annually?
It says annual, I believe, in the regulation.
Thank you.
You're welcome. It's not a bad idea though to kind of keep it on your checklist, so you know when you do your monthly walk or weekly walk or whatever, just to make sure people are following it. But that's a little bit different than audit under the lockout tagout regulation, but it's not a bad idea to have it on your
Inspections for sure.
walks. Yeah, inspections. Yeah. Okay, so what do? You got the citations. You didn't respond to the Form 1BY. And you got your citation. You got 15 working days to file the appeal from the date you received the citation. Now, my tip is don't use the date you received it unless you have to. Just use the date that's on the citation that was issued. And I'll tell you why. One is if you blow that 15 working days thing, you're dead in the water about 99% of the time. Very hard to get around a late appeal. Number two is there's no way to receive a citation before it's issued, so there never is a question of meeting that 15 working day if you just use that as your date when you send an appeal into the Cal OSHA Appeals Board. And the Appeals Board, if it is beyond that, a lot of times they will require you to prove timeliness, so they're going to send you something that says, hey, what you have a proof of receipt or something like that, or the division they will send requesting proof of when they mailed it and then when it was received. So it's just a big quagmire. So you're better off just using the issuance date to prove timeliness of the appeal. Now abatement. Technically, you don't have to abate until the appeal is over with. However, there's a couple things you need to think about. One is it goes into expedited, and you may not want to go into expedited track, which gets you to trial in 140 days, which you may think is great. But the longer things space out, the less interest the division sometimes have in a final outcome. So adding time isn't a bad thing. But if you don't abate a serious, then it's in expedited. So if it's a serious citation, you want to abate that within the 10-day mark. And also to get abatement credit, which is a 50% discount on the penalties, you want to abate the seriouses within the 10-day mark. Generals are considered abated. You don't have to worry about those until the end, but it's the serious citations that you want to do that. Informal settlement conference, an informal conference with the division. A lot of folks used to do those. They get the citations and do those before they appealed. My personal recommendation is you wait to do that. You file the appeal, and then you get a copy of the file. You can go through so you can talk intelligently with them about what they have and don't have in their file that supports your position. Otherwise, you're kind of boxing blind. So I prefer to wait, and it's and just to show you, just to give you that, like if I'm representing you, I don't want to go early because I know I'm not going to get as good an outcome, and you're going to pay me to do something that's not going to be effective for you, and I don't need to do that. I'll do it later whenever it can be effective. And then the last thing you end up with is a hearing or a trial down the road. There's a couple protected activities that employees can do. They're allowed to contact OSHA. They're allowed to participate in the inspection. They're allowed to have exposure and injury records. They're allowed to report their own injury. You got to make sure you do. And safety hazards. Just keep in mind those are protected activities for employees. Criminal liability, I'm not going to spend a whole bunch of time on this. Just briefly, remember with the criminal statutes, if you have a fatality, now it does apply to serious injuries. I've never seen it applied in 20 years. It's always a fatality. Has felony for the corporation, 1.5 million plus court cost of 3.2 times the fine. Victim restitution. Now here's where it's important. If you're a supervisor, there's individual liability. Now, in my practice experience, I've handled a ton of these. They don't usually hit the supervisor, but when they do, it's usually not a good thing, obviously. But in the resolution of it, there have been, and I've had these cases where they say, okay, supervisor, you're going to get a $30,000 fine. And as part of the plea agreement, the company cannot and will not pay that for you. That has to come out of your own pocket. And so if that happens, that's a violation of the probation and they go to jail. So there's a lot of ramifications when you're a supervisor you need to be aware of in California with that. Now, just a little bit, and we're going to go into crisis mode now. Now you've had a fatality. What do you need to think about? Who your crisis team is. And it really, you guys that are health and safety on the phone or human resources are a critical part of this team. You're going to have external folks, whether it's counsel, consultants, those sorts. And then you need to pick your team leader, which like we talked about earlier, whenever you have a crisis. So let's talk about the crisis team part, the health and safety, the safety manager or director. These are what you want them to be doing on this team. Ensuring safe access to the project whenever the crisis is going on. Making sure the accident scene's preserved. Making sure everyone that shows up is wearing their PPE or has access to PPE if you're going to provide it for them. And that's being enforced and followed. Now, accident investigation report, you have to be careful with that because as a safety professional, we want to get out there and do that accident report and root cause and all the details and all the things. That's great, but when you have a fatality, remember the criminal stuff I was talking about? You may want to think about having that done under direction of counsel and having a less onerous one that is very limited in detail just to comply with the IPP, and then have your root cause privileged and protected by being done under direction of counsel, and then make sure that you've notified Cal OSHA or whatever agencies you have to notify. Then your external team, people like me, experts in certain fields, public relations. You guys, most of you all have a public relations department. It's probably internal, not external. And then anyone you need for technical, operational recovery, getting the plant back up and running, whatever you need to do with that. Could be external, could be internal, but oftentimes is external. The team leader, which may be the same as the health and safety, it may be someone different, but they're going to direct they're going to manage this whole thing, going to manage the activities, ensure that everyone's needs are met, meaning HR's needs, the safety team's needs, whatever counsel needs, experts needs, facilitate the communications to all those because we want limited communication internally and externally regarding a fatality. And then, of course, providing the status reports to your upper management. Now, human resources also plays a big role when you have a fatality and a crisis like this. One is making sure you've identified who's the affected employees related to this. If it's a fatality, attending to the family members because they're going to be wanting to know what's going on, how did this happen, so they need to be able to communicate without making admissions. They're going to be questions about hospital coverage or funeral expenses, all the things that go with the HR bucket. So as you can see, to manage a fatality or a very serious injury, there has to be teamwork with a lot of moving parts to do it effectively and efficiently and protect your liabilities. Dealing with the family this is the hardest part of my job as an attorney in workplace safety, dealing with fatalities and the families. It's really hard, but you want to make sure that they are getting things addressed promptly. The communication lines are open, especially with the human resources for folks. and they're getting their needs met. And their personal items, that's another issue, sometimes getting their personal items returned. You guys all have probably a professional PR person with the district that does all of this, so I'm not going to spend a lot of time. Just important to make sure they're communicated with in a crisis like that. Then we also have the aftermath. What do we got to deal for the triage? Well, of course, getting emergency services out there, maybe evacuation. You might have, generally speaking, when there's something like this happens, non-essential folks are off the job and sent home, even if they may be someone that Cal OSHA needs to talk to or something, because they are in crisis, they're dealing with what just happened, and they don't need to be hanging around talking to each other, and that's how rumors spread. And of course, the other thing we do in this is make sure, and this isn't on my slide, but I always recommend getting crisis management assistance like EPA for the counseling for everyone at the site that's dealt with a fatality, and that's very, very, very important. Every fatality, we make sure that that's available and try to encourage folks to do. We usually have them out the same day to talk to maybe the ones who are right around it or working as a co-worker with the deceased. So important there. The other thing with triaging is making sure you preserve the scene. You know, this happens too, is sometimes evacuation could cause damage. You need to make sure you're trying to control that, minimizing damage. If there is damage, documenting what was damaged as a result of the evacuation versus a result of the accident to the extent you can. Sometimes an emergency and trying to save a life, and there isn't time to do that. Make sure their press folks handle your press information. Never say no comment if they catch you going out the gate. You're the safety director, and they say, "Hey, are you the safety director?" You know, yes. Do you have a comment on the accident, the fatality? I understand. My heart goes out to the family for their loss, and any information that you need. Here's our press person. So kind of be prepared for that, especially if something like that happens. On the communications, you always want to make sure that you're focused on the integrity, safety, security, all the things as how you want the public to view you in one of these situations that could be catastrophic to one of your fellow employees. Okay, looks like I wrapped up a little bit earlier than 2 hours, Marjorie, but just in conclusion, we can do some Q&A for the next bit of time. Be prepared for a crisis because you never know when they're going to happen, right? And I will say that 90% of my fatality cases that I have for clients is their first fatality. So it isn't something they expected or ever happened to them before. And so you don't want to be learned and practiced in handling a fatality. Because that means you've handled them before. But knowing the information we talked about today helps prepare you if that should happen. Very important to know what your rights are as an employer, as an employee, as a supervisor, so that you can manage your investigations. Obviously, another key is avoiding admissions. We talked about ways to do that. The other thing, remember the balancing act, manage cooperation. So you got to balance that cooperation with preserving your rights. And last but not least, of course, we all know COVID-19 is not going away soon. We're still going to be dealing with that and the regulatory changes as employers and that ever-moving target and frustration point. But just know that we just have to keep grinning and bearing it and dealing with it as we go down. And Marjorie, I know, is involved with the Cal OSHA stuff all the time. She'll get you updates on as things change with COVID-19. I see her emails and her posts and communications, and she's always ahead of the curve on it. So I know she'll keep you posted on those ever changing things with COVID-19.